Start off, I just want to again thank Mike and the other organizers for inviting me. I really appreciate it. It's a very great honor for me to be here and to be able to speak to all of you. I'll just for the next 10 minutes present a very abbreviated version of the argument in my paper. And I really look forward to your questions and suggestions for improving it. Legal scholars, including originalists, often try to relate text to history. We use historical materials, and there's a question of whether we're using them just as a dictionary to define terms that appear in the Constitution, or whether these historical principles that aren't themselves recorded in text nevertheless carry some legal effect. Modern constitutional theory, I think, has come a long way in arguing that it's the meaning of the ratified text and not the substantive hopes and dreams of the authors that ought to carry legal force. At the same time, that focus on text has made it harder to explain certain aspects of legal practice that are as old as the founding. So you think of the following questions. Can the houses of Congress punish or imprison private citizens for contempt? Can the president remove federal officers at will? Are judges required or even allowed to apply stare decisis in constitutional cases? And do the states have sovereign immunity from federal question suits? These seem like constitutional questions, and a lot of people try to answer them that way, sometimes relying on founding era history. But the answers aren't always grounded in specific textual provisions, or are done so only in a particularly strained manner, as opposed to broader historical analysis. And without presuming to give a final answer to these questions, I want to suggest an approach to answering them that I think could be fruitful, and I think follows from our existing legal commitments. In other words, I want to identify a set of cases in which we can go outside the text without going outside the law. These are what I call constitutional backdrops, rules of law that weren't imposed by the Constitution, but were instead left unaltered by the Constitution, and in fact are protected by the Constitution in various ways against certain kinds of legal change. I think the backdrops are a surprisingly important category in our legal system, and that recognizing them as a category helps us resolve some otherwise insoluble disputes. And I want to give three quick illustrations of backdrops. First, some backdrops are just rules that the Constitution incorporates by reference. Think of the ex post facto clauses. Now, obviously, to find out the meaning of a term like ex post facto, we look to legal understandings at the time. Did it include civil laws as well as criminal laws? That's just ordinary interpretation of what the text means. Even though we look to history, that's not really a backdrop. I'm interested in something else, namely what happens when we're done interpreting the text. The ex post facto clauses tell us that we can't criminalize acts that were legal at the time. So yesterday's criminal laws are forever part of our law, and we can't completely override them without a constitutional amendment. But of course, yesterday's criminal laws aren't actually part of the Constitution. They're just ordinary criminal laws. If we want to know what they said, we're not going to find it in the text. We know, in this case, what the text means, but we need to look elsewhere to find out the rules of law that it preserved from change. So this is an easy, almost trivial case. The Constitution tells us to look to some external source of law for certain rules we have to apply. Here's the second example. Some backdrops weren't incorporated by reference, but merely left in place and protected. So think of the rules governing state borders. The Supreme Court, when it decides border disputes on who owns Ellis Island, has a bunch of traditional rules about the priority of different states' claims, how rivers move by accretion or avulsion, things like that. Most of these are common law or international law rules, and they've been applied and recognized as part of our law ever since the founding. But they're not in the Constitution. The text says nothing about them and just leaves them alone. That's nothing special. In my view, the text left almost everything alone. The Constitution did not declare a sort of legal year zero and repeal and replace all prior law. Instead, it was silent on the vast, vast majority of legal questions. And in our common law system, as Justice Breyer put it in a sovereign borders case, silence is not ambiguity. Silence means that ordinary background law applies. As a result, if these background legal rules aren't abrogated by the Constitution, they just keep on trucking of their own force, subject to the normal rules of abrogation or repeal. The text does, though, sometimes restrict how these external rules can be changed. Under Article 4, for instance, you can't form states from parts of states without their legislature's consent. So neither Congress nor any state can redraw the borders on its own. And besides, under Article 1, no state can engage in war. So New York can't pass a statute that annexes part of New Jersey. The upshot is that these old uncodified rules about where the sovereign borders are and how they're found still have legal force for us today, not because they were encoded in the Constitution somehow, and not because they somehow became part of the meaning of the word states, but because they were just left alone, and no one in particular was empowered to override them. So a third example. Some backdrops result from the fact that our legal system uses language in a way that logicians call defeasible. We don't expect a legal text to name all the necessary and sufficient conditions for its application. Instead, it can be defeated by principles elsewhere in the law. So we can teach students that a contract to be valid requires offer, acceptance, and consideration. And we're not lying to them. We're not giving them wrong information, even though we failed to mention capacity or the statute of frauds. Or when a new criminal law says it is unlawful for any person to send live geese through the mail, we can accurately say that the statute lists no exceptions, but that doesn't mean it abrogates an uncodified common law defense of duress or of diplomatic immunity. This isn't because of any vagueness in the text per se, or an ad hoc updating of a clear statute. It's just the normal application of a principle of common law in derogation of which our statutes are read narrowly. Reading for any person to override duress or diplomatic immunity in our system would be a misreading of the text. In the same way, some principles that the Constitution left unaltered might in some circumstances trump the text. Even a fully adequate, historically sensitive understanding of a particular clause's meaning can be defeated by an independent background rule. And if it is, the constitutional rule we're stuck with is the narrower, defeasible rule, which we can't restore to our previous understanding without passing a constitutional amendment. One potential example of this I offer in the paper is state sovereign immunity in federal question cases. So many defenders of sovereign immunity don't claim that all the traditional immunity rules were somehow hard-coded into the 11th Amendment, especially for things other than state diversity. Instead, they argue something like this. Before the Constitution, a sovereign state was not amenable to suit by a private party without consent. For various reasons, we shouldn't read Article 3 as abrogating that rule. Thus, the states remain immune from suit unless that immunity has been validly waived or abrogated. Now, without taking a position historically on whether these claims are true, I want to point out that they take the form of a backdrop. The old rule is left in place and, in fact, protected against certain kinds of change. And the reason is defeasibility. An independent rule about states' capacity to be sued acts as an exception to the otherwise applicable grant of judicial power in Article 3. And in fact, it was defended in these very terms. So in the Virginia Convention, Madison says sovereign immunity is like rules of coverture, which prevent married women from suing without their husbands. His claim wasn't that Article 3 sort of adopted coverture or made it part of the Constitution or hard-coded it in there, just that it left capacity rules as it found them to operate of their own force. Even though the federal question grant then includes all cases, that doesn't override the ordinary background rule, whether of coverture or of sovereign immunity. If that's right, then viewing sovereign immunity as a backdrop might also illuminate Congress's power to abrogate it. If this is a common law rule, not a constitutional one, then in theory it can be trumped by statute. And whether Congress can actually do that is a standard question of enumerated powers. You have to look elsewhere in the text to get your answer. Now, some people say that it can't, that abrogation is the kind of power, like commandeering states in prince, that would have been granted explicitly and not just by implication. If so, then the common law immunity has a content that's also a backdrop. Namely, the states get that certain degree of immunity and no one can do anything about it. But even if Congress can abrogate sovereign immunity, the fact that it actually has to, that Article 3 is subject to these kinds of potential immunities, is itself a backdrop rule, something not actually expressed anywhere in the Constitution, but that we're stuck with until we amend the text. As the paper makes clear, I think that backdrops are a surprisingly important category of American law. And in the paper, after describing the theory, I give 3 examples of potential areas that might helpfully be understood as backdrops. For instance, for 200 years, the houses of Congress have claimed a power to discipline non-members, not just members. This power isn't in the text anywhere. It's not obviously part of the definition of legislative powers granted by Article 1, but it was a power that British and colonial legislatures had traditionally enjoyed. So it might be understood as a common law legislative power that was unaffected by the Constitution, but that was later protected, for instance in the Rules of Proceedings Clause, from certain forms of legal interference. Or you might think of the president's alleged power to remove executive officials in this way. Some might argue that removal power is just part of the meaning of the words executive power, that viewed in a historically sensitive way, executive power was just synonymous with the power to do X, Y, Z, Q, and remove executive officials at will. Linguistically, I think that's a hard claim to win. But maybe the words executive power have a particular meaning, such as the meaning that Madison and Hamilton may have suggested, something like the powers ordinarily incident to the executive. In that case, powers like the removal power might come in not as a matter of definition, but as an incorporation by reference, as an external content that provision calls in. Or take the more controversial case of stare decisis. Some people argue that the precedential practices of US appellate courts are just part of the linguistic meaning of the judicial power referred to by Article 3. So for instance, the Eighth Circuit panel decision in Anastasov. But even if that claim were wrong linguistically, it might still be that stare decisis is a common law doctrine which the Constitution doesn't abrogate, and which, at least to some extent, depending on your theory, be immune from legislative or executive interference. Now, as I explained in the paper, I think that there are many, many areas where backdrops could potentially be a useful tool. The president's war powers, the role of international law in the federal system, the law of personal jurisdiction, the powers of admiralty courts, the scope of habeas, the insular cases. It's a long list. It may be the problem of having a hammer and thinking that everything is a nail. And I also in the paper address various objections to the backdrops approach. Whether it's just another flavor of history-sensitive interpretation, whether it would entrench the dead hand of the past in a particularly awful way, whether it depends on the existence of an unchanging common law, whether it's consistent with Erie, and whether it would open a Pandora's box of unenumerated powers and rights. I'm sorry I can't say more about those potential objections now, but I'd be happy to discuss them with you and hopefully hear some others today. But in general, the point of the backdrops approach and what I hope to achieve with this paper is to show that it's sometimes okay that the text doesn't answer all of our questions. When the text runs out, we don't always need a sort of very open-ended form of construction or structural argument. We could sometimes just continue the lawyer's work of sorting through otherwise applicable law. If the Constitution doesn't say anything about accretion or revulsion of rivers, that's not a gap that we necessarily need to fill as interpreters. It's a gap that's automatically filled by the applicable background law, which just keeps on operating of its own force. And that ordinary law is subject to ordinary means of legal change, unless, of course, it receives protection from some other part of the text. Thank you, and I look forward to your questions.